Hi, everyone. Thank you very much for joining us today. In fact, for us, our legal team in Kazakhstan and our friends at CMS, it's a second event we do together. So the first one was last year, also on dispute resolution. And what we found is, of course, people have to deal with disputes, but I guess most commercial businesses, commercial enterprise would like to avoid them. That's why we thought, okay, probably this year we should focus on how to use early dispute management to resolve the disputes at the very early stages, not to get into actual arbitration or litigation, etc., and watch out for some early signs of potential disputes when everything is perfect, when everyone is a friend, etc., etc. That's why today we'll be focusing more on sort of dispute resolution in terms of prevention of disputes rather than actual sort of litigation and other means of dispute settlement. So without further ado, I would like to introduce our speakers. Our first two speakers are from CMS, and then we'll have a speaker from my own firm, KPMG, in Kazakhstan. So our first two speakers are dispute resolution partners based in UK, Rob Wilson and Sarah Grenfell. So Rob, probably we'll start with you, right? Thank you.
Rashid, thank you very much indeed. And ladies and gentlemen, good afternoon. It's very nice to be with you today, albeit virtually. I'm sorry that Sarah and I cannot be with you in person at these difficult times. And I hope that you and your families are all keeping well. As Rashid mentioned, I'm Rob Wilson. I'm a partner in the infrastructure, construction and energy team, energy disputes team at CMS, and I'm based in the UK. Sarah Grenfell joins me today. Sarah is also a partner in the infrastructure, construction and energy disputes team. The majority of the work that Sarah and I do is obviously of a contentious nature. It covers a mixture of commercial litigation, international arbitration, and also mediation. And Sarah and I are both involved in advising on projects before litigation or arbitration, as well as dealing with the disputes as they go through that process. And the aim of the today's talk and generally our aim is to try and assess risks and to avoid disputes for clients and only to end up in litigation or arbitration where that cannot be achieved. Now, moving on, hopefully you can now see the second slide on the screen. CMS is a global full-service law firm. We operate in over 70 cities across 43 countries around the world. We were ranked 5th largest law firm by headcount in 2018, as we have a staff in excess of 8,000 people. The next slide shows the locations where our offices are currently located. So moving then to the substance of what I want to cover with Sarah and you all today. There are two elements to the presentation that we have for you. The first element relates to the management of disputes and dispute avoidance, and the second element will focus on mediation and arbitration. So in relation to the first element, we're going to touch on how one goes about recognizing and managing a contentious situation, then move on to steps that you might take when the dispute first hits your desk. We'll then consider early case assessment and the development of a case strategy and management of the issues. We'll then move on to settlement negotiations, the timing of those negotiations and tactics and who might be involved. We'll consider the management of expectations and how you might engage if you're an in-house lawyer with your business, or if you're in the business and not in the legal team, how you might then engage with your in-house lawyers. And finally, Sarah will talk about document management. And as I say, the second half of our presentation will relate to ADR options, in particular mediation and arbitration. So if we move on then to the management of disputes and dispute avoidance, and at this stage I'm going to hand over to Sarah.
Thank you, Rob, and I echo everything that Rob has said. We're really delighted to be speaking to you today. It's a much changed environment to be doing these sorts of things virtually, as opposed to coming and meeting with you in Kazakhstan. And Rob and I look forward to being able to do that again at some point when travel restrictions ease. One of the things that I think is always at the forefront of our mind when we are advising clients on disputes is if they were to have taken steps earlier, then perhaps they might have been able to avoid getting themselves into a formal dispute. And really that is always the aim, and so that's the aim that we have for our clients, that they can avoid disputes wherever possible and that we can help them to do that. And so what I'd like to talk you through just now is how you can recognise and manage a contentious situation. And really there's two different focuses here, and the first is how might an issue arise out of the contract, and the second is what sorts of incidents might occur on a project or in relation to what the contract relates to, where a dispute might then follow, and how can you control those circumstances. So looking specifically at the contract, I mean, it's something that we often say that we will see where a contract is executed, everyone's on very friendly terms, and then the contract is in some cases set aside, and people don't tend to refer back to it and to actually manage the project by reference to the contract. And that can certainly cause problems if you're not following contract procedures. So it can be very sensible, once you've completed a contract, once you've executed it, to carry out a review process. And that's something that you can do with your lawyers can do for you, whether that's internal or external. And that really can be a process of looking at what the project is meant to achieve, trying to identify certain requirements under the contract that need to be met, and for the team who is executing the project or managing the project to really understand what those contract provisions provide. And that really brings me on to contract management. Now, some examples of that are variations. We will often see disputes which concern numerous variations, where it would have been beneficial at some point for parties to actually make sure that they follow the process properly. And having failed to do that, it has led to problems and potentially disputes. So you should always be aware that if you're amending the contract or you're varying the contract, that you look to what is required under the procedures. Another a common area for disputes to arise from is force majeure events. There will often be disagreement between the parties as to what actually constitutes a force majeure event. And if you look to most force majeure clauses, it's imperative that you actually give notice that an event has occurred, and often there's certain steps that you have to take and information that you might have to provide. So it's very sensible to understand what you actually have to do, because if you meet those requirements, then you're setting yourself up for success later on. Equally, if you're on the other side and you are receiving notice of a force majeure event, it can pay to actually investigate the event at the time and take some steps to understand whether that has actually occurred. I think we would also see issues in relation to payment when that's made and necessary requirements, insolvency risks, and a legal analysis that you can take in relation to the contract to understand what your requirements are. So that's all things that we would recommend after the contract's been executed and as it's being managed. Now, in relation to incidents which occur, and I'm thinking particularly in the sectors that I work in the infrastructure, construction and energy space, but this can apply across many sectors. You can have an incident that occurs where there will be disagreement between the parties about what has actually happened and who is liable. And it's very important in our experience to establish early on what has actually occurred factually, and often to get expert input into what has occurred. So that is something that we would recommend. That can then feed into what response you should be providing, and with the help of your lawyers, you can also analyse what your obligations or rights are and take a view on that at the time. It's always important, I think, to have an informed position, and that's really the point that we are making in relation to that. I'm now going to hand back over to Rob, who is going to speak to you about further things to recognise and manage a contentious situation.
Sarah, thank you for that. So we've now looked at, with Sarah, at where these situations might arise, and there are three elements I want to just focus on, which are shown on the slide. The first is disputes of projects. Now, Benjamin Franklin, who was, of course, one of the founding fathers of the United States, is credited with saying, "Fail to prepare, prepare to fail." And it's quite clear that in any situation, you will only manage to actually succeed in what you do if preparation has been appropriate in that regard. So disputes of projects, what I mean by that is, like any successful project, matters should not be left to chance. If you wish to try and ensure that a certain result is going to be achieved, then you must plan for that result. And the same applies, therefore, to a contentious situation. If you find yourself in a contentious situation, then you should not be leaving things to chance. You should be considering matters quite carefully. So good project management is essential, and it's essential for the reasons shown on the slide, to give the dispute avoidance the best chance possible, to try and avoid getting into litigation, arbitration, and to try and resolve the differences that you have with your counterparty without extremely costly procedural matters being dealt with through the courts or through arbitration. Secondly, to avoid surprises and mistakes. Therefore, you must prepare to identify realistic goals and to avoid expectations being out of kilter, out of not known or recognized by those you're working with. To be prepared for litigation and arbitration if that cannot be avoided. To save time and money and to achieve the best result possible. All of those require good project management, and that is necessary from day one, as soon as the contentious situation arises. The third element here is, well, how you actually go about achieving that successful management of the dispute. And firstly, you can do that by ensuring that you consider the best structure and strategy. And you do that by identifying the issues early on from day one, organizing your documents, making sure that you have all the documents, making sure documents are not being destroyed. And Sarah will talk more about that later. Planning how you will proceed. Again, leaving nothing to chance. So all of that should be done or start being done from day one, as soon as the contentious situation arises. Secondly, it's important, very, very important, to involve the right people. And again, Sarah will talk more about that in a moment. Good project management can only be achieved with a team approach. And a team approach requires there to be a clear understanding as to who is to be involved and as to what each member of the team is expected to do. Identifying the right people and the coordination thereafter is therefore very, very important. I'm going to switch off my camera because it's showing that I've bad reception. But moving on then, hopefully you can still hear me. You must have clear objectives in relation to what you're seeking to achieve. Think about what you want to achieve. Do you want to preserve the relationship that you already have with your counterparty, or is that not or no longer important to you? Do you want to complete the project to which the claim relates, or is that project now over and therefore what you now want to focus on is just either resisting a claim or pursuing a claim and being compensated accordingly? Clarity of objectives. So with all of that in mind, I'm going to hand back to Sarah so that she can take you through the next slide.
Thank you, Rob. And I'm sorry we're switching on videos and off, but I think as Rob is getting a message, as am I, about internet connection being problematic, and we obviously want to make sure that you can hear us properly. So people often, actually I'm going to start this with an anecdote about a matter that I have worked on where they had an internal policy that if something was in the claim stage where it was being put forward to the other side but hadn't crystallized into a dispute, that the people who would be involved would be the project team or the commercial team. And once the matter crystallized into a dispute, it would be handed over to the legal team, and the legal team would manage, for example, preparation for an arbitration and steps following on from that. And it had been quite challenging to really make clear that it's really integral that you have both legal and commercial and often finance involved, but all at the same time. And so the last thing that you want is to have a claim that has been prepared solely with operations or commercial input, but hasn't had any input from legal, because it can compromise your legal position. And those are the sorts of points where it's obviously ideal to have some legal analysis input when you're identifying what the rights or obligations are. So I would always say that it's very good to have a holistic approach and make sure that the people who knew what was happening on the ground day to day are involved in any investigations or claim preparations or preparing correspondence to the other side. But also that it's very important that you get legal input to make sure that you're not going to be compromising your position subsequently. And actually, one of the things that we're often asked to do now by clients who have had big disputes and have learnt the benefit of this is to provide a project advisory role where we are day-to-day providing input on the project if needed, because that means that there is legal input alongside the commercial oversight. I think you also will want to think about what external team you might need. So it can be beneficial to have external lawyers because they may have specific experience in the sector or in relation to disputes, and also whether it's an ideal position to have an expert come on board early. The position I spoke about earlier, where you have, for example, a root cause analysis that's been carried out, it can be handy to, for example, have that provided to an expert and have that tested. Or if there are allegations from the other side about certain things happening, you might want an independent party to provide a view to you, and they will be detached from the project and will provide an objective viewpoint. So that can always be very handy. The next point really to make is about how important it is to ensure that there is communication and the lines of communication are well understood. And so here from the outset, if you have a significant issue that has arisen, it can be very handy to agree who is going to be involved and informed about what happens, to work out internally and externally who should be kept up to date about things, and then also what methods of communication there will be. I mean, I think these sorts of things apply equally to managing a project and seeking to avoid disputes, and also once an issue or a dispute arises. But clarity on these sorts of things will mean that everyone understands that what's happening on the project and that they're kept up to date, and they will know the agreed method for that. So, you know, what we would see most frequently is that people do a lot of communication these days by emails, and obviously there'll be lots of meetings. And the thing to be conscious of there is that often that will record exchanges between parties. And I'm going to come on to that later in relation to document control. It can be helpful, very much so, to put in place a communication protocol, and so that it's understood, for example, if something is legally privileged, if you're communicating with the other side, you know who you're meant to be speaking to. Often under contracts, I'm sure that everyone I'm speaking to will be aware of this, that there will often be notice provisions that need to be complied with, that will indicate specific people who need to be advised of things in certain circumstances. And so it's important to make sure that you're aware of that. And then the last thing I'd say really is the real danger of informal communication when a project is live or if an issue arises. And that's because, and I'm speaking specifically here in the context of international arbitration and disclosure, but I would say that it applies equally to English court proceedings, is that you will have a process where the other side will make document production requests of you, and you will do the same with the other side. And I am always, I almost always have clients who are surprised by what falls within a document or communication. And it will be as broad as WhatsApp messages, and it can include photographs if you've had something go wrong on site and someone has taken all the photographs, obviously emails, text messages, calendar appointments, notebooks. It's really a broad, it's a broad pool. And so you will just want to be conscious when you are preparing communications, whilst you are in the throes of an issue that has arisen, that you don't put anything down that's damaging, because it could be disclosable or required to be provided to the other side subsequently. Rob's now going to be speaking to you about the steps that you might wish to take or should be taking when a dispute hits your desk.
Sarah, thank you for that. So, so just picking up on some of the themes that both Sarah and I have just covered when thinking about how you might recognise a dispute and how you might prepare yourself. So, as we explained, it's very, very important that you have good project management and that you have a team approach, and therefore very important that you have the right members involved in that team and that they know what they are to do. And as Sarah explained also, it's very important that it's not just seen as perhaps being a matter that then passes from the business to the legal team at a particular given stage, because for one to stop being involved and the other to start being involved, and for there to be no crossover, or in fact no ongoing continuous relationship, is never going to be the best way to achieve a resolution to the dispute. So the dispute has arisen on a contract or in relation to a project or out of an incident. I won't call it a dispute, I'll call it a contentious situation. That contentious situation has arisen at a point when the legal team may not have had any real involvement in the matter. So the business has been dealing with that, the operational side of the business. And therefore, it is the operational side of the business that has all the knowledge and knows everything about what has gone on. Now, clearly, they need legal advice, and therefore they turn to their in-house legal team. But the in-house legal team can only work with the information that they know and understand. And with that in mind, they therefore will often benefit from getting a briefing note from the operations team. It needn't be a very long briefing note, even half a page is better than nothing, because that briefing note can then assist the legal team getting up the learning curve to understand what the key elements are that may be in dispute, and what they also can understand, hopefully from that briefing note, what the most important drivers are for the business. Now, with that briefing note, they can then identify the issues at that early stage, and that will help both the business and the legal teams then focus on the right things and focus on the same things and work together in a team approach. The other element that needs to be carefully considered when the dispute or the contentious situation hits your desk is whether or not the project documentation is in the form in which it should be. Like any good project, it's always good to ensure that with a contentious matter arising, that documents are in good order and are complete. And often when matters arise and we get involved, well, firstly, quite often we don't see a lot of the documentation until some months after we've initially become involved, because perhaps it's not been so readily available. Sometimes we find that, in fact, the documentation that we need to see has already been destroyed or disposed of, or it was on a laptop and it was never stored centrally, and as a result, we don't have a record of what was said and done at the time, because perhaps the laptop has been erased because the individual involved has since left the company. The second thing to consider is whether or not there is outstanding correspondence, for example, in relation to variation order claims or in relation to other matters. Sarah touched upon force majeure, and for example, you know, if a force majeure situation arises, then I think it's important at the stage that it becomes contentious to immediately evaluate the extent to which the process has actually been followed, the extent to which parties have actually complied with what they should have done under the contract. Likewise, with regards to payment disputes, the first thing to check, of course, is whether or not the sums that you're wanting to claim have actually been properly invoiced. Have the invoices been sent out in a way that is compliant with the terms of the contract? There may also be notification provisions relating to warranty claims, for example. I've touched on force majeure already. And finally, in relation to insurance, every contract and every matter will usually have some form of insurance policy that might be triggered as a result of a claim, even if it's relating to an incident or relating to contractual works. There is likely to be an insurance policy there, and you should immediately look at that insurance policy and consider whether or not a notification has already been made, and if not, then one should be made as soon as possible. So just generally at this stage, think about what actions and what documentation you need to be taking. Now, with that in mind, I'm now going to hand on to Sarah, and she's going to talk to you about early case assessment.
I'm really going to run through here. It's a bit of a map as to why you would have an early case assessment. What is the reason for doing it, and what benefit do you obtain? And I think I'll start by saying that I often have matters that come to me where the incident which gave rise to the contentious situation or the dispute happened a number of years previously. And in those circumstances, it's simply human nature, and also the way that projects are run commonly, that it can be difficult to identify all the relevant documents. Some of them may have been destroyed or lost, as Rob said. You can have people who have left the project, and even if you have the perfect scenario where everyone is still around and all documents are there, in our experience, it's simply, you just simply can't expect people to have a good recollection of events which occurred such a long time ago. I struggle sometimes to remember in detail what happened to me a month ago when I'm very busy at work, so a couple of years can put it really into the far distant past. So the real purpose of an early case assessment is to seek to uncover the whole story. And really the importance of that is, if you don't know what the whole story is and you don't know what your rights are, then it can be very difficult to take a stance on in relation to the issue towards the other side. Or you may end up taking a stance where, had you known in reality what the position was, objectively speaking, earlier on, you would have had a better chance of settling the issue with the other side without the need to actually go to formal proceedings. So by uncovering the whole story, you can assess the merits of the case. You can also understand at that point what your rights are under the contract. Some of the points I mentioned earlier about managing the project, so you will be able to identify what you have to do to preserve your rights under the contract. Perhaps you will also at this point understand that there's a very severe limitation on liability, and if you understand what that means, it may lead you down a different path to what you would otherwise take if you think that you can recover all of your losses, for example. Another thing to be looking at this point is the dispute resolution mechanism, so that you understand where you're going to be heading if you can't resolve the issue, and what your options are. Something to be considering in that context is, do you go straight to arbitration, or are there necessary steps that you have to take which are seen as conditions precedent to commencing proceedings? And that, for example, might require you to issue a notice of dispute to the other side. It might require a certain period of time to pass, and you might have to also attend mediation. So it's useful to just be aware of that. So some of the things that you ought to do, you need to evaluate the facts, and that will necessarily involve reaching out to people on the team who can speak to those facts and have first-hand knowledge. Evaluate what your risks are, your chances are of succeeding with your position. Even if it is only at a high level, it's a very useful exercise to be undertaking. Something that I think is also a good thing to be doing, and I'm sure Rob will agree, is to be looking at the position of the person or the party on the other side, because that can be valuable for assessing your own strengths and weaknesses, and moving forward, developing a view on how likely they are to settle early. If they have a very poor case, then you can seek to exploit that. But if they have a very strong case, then that will inform your position about where you might stand and what the prospects are of settling if you insist upon something that's out of step with what your rights might be under the contract. And so all of this really assists with early resolution, and that's obviously what we're seeking to achieve, or we know what our clients are seeking to achieve. So just moving on to some of the key things to do, and these are important going forward, because if you take these steps at the time that an issue arises, it's obviously perfectly possible that an issue will remain a live issue or an unresolved issue for a number of months or a number of years. But if the steps have been taken at the time to actually do this work and to secure the evidence, then you will be setting yourself up far better later on if you can't resolve things in the near future. So the things to be looking for are project documentation. Obviously, if you have a good document management system, and it's easy to identify where the relevant documents are held, that's obviously very useful. To the extent that that's not the case, or that these sorts of documents, for example, sit with people who might subsequently leave, it's helpful to collect those. Examples I would be thinking of particularly here that I've seen in the past are where people leave and they take a notebook with them, and they were a critical person in the project and took notes of meetings. It's also, in my experience, common practice for people to not save things to document management systems, sometimes because it can be challenging to do so, or they're working remotely, and so they will end up having a lot of documents sitting on their desktop, and they can be lost if someone ends up leaving and they take the computer with them. You should be thinking at this time as well about any we call them a litigation hold, but it's essentially a stop on producing documents that can compromise your position, or destroying any documents that you might need subsequently. If you have insurance, if an insurance policy in place, there will often be, will almost always be, requirements that you notify your insurer or take certain steps, and so you should be thinking about that, and also preparing contemporaneous reports. One thing I would add about preparing something contemporaneously when an issue has arisen is that, and this is probably best told by way of example, I worked on a matter where a steam turbine blade had liberated and caused a plant outage for a substantial period of time. And the assertion that was made by the other side was that the party that we acted for hadn't properly controlled the steam and the chlorides that were in the steam for the turbine, and that it was exposed to. And so you would think very helpfully the client, prior to engaging legal counsel, had prepared this report, which provided a fairly damning position on the way that they had managed the water and steam for the turbine. And really they did this without any legal input and with the best of intentions, but it was a document that ended up being disclosable. And what was probably even more annoying at the time was that it actually wasn't totally accurate, in the sense that when we got an expert on board, they disagreed with some of those comments. So you want to always be very circumspect about preparing a report and seeking to have it as a privileged document, which if you retain external legal counsel and have experts on board, there are ways to ensure that reports and draft reports can attract privilege. And so you should definitely speak to your lawyers about that. And then also thinking about things such as preparing for document production as you get closer to formal proceedings, if you can't avoid the dispute going that far. And in the initial stages, it can be very helpful to interview witnesses. For the reason that I spoke about before, you can have witnesses leave, and often because of the sorts of matters that we work on, you might have someone who was in Dubai for a period but then returns to Italy, and it can be much harder to track them down and to take witness evidence. And so it's obviously so much easier to get people involved early on. And so we're always proposing that parties do that if an issue arises. I'm now going to be passing back to Rob, and he's going to be talking to you about settlement negotiations.
Thanks, Sarah. So just to recap briefly, you've now identified the issue and dispute. You've identified who in the business and should be involved in dealing with that. You've got your team there. You've done your early case assessment. So what now? Well, this seminar is all about avoiding disputes. So before you start thinking about going to litigation or arbitration, consider, should you actually be seeking to actually try and negotiate matters with the other side, or at least discuss matters with the other side. You may think you've got a very strong position. They may think the same. They may think they've got a very strong position. Now, there's still scope at this, there's still potential at this stage, therefore, for you to persuade the other side that you are right and they are wrong, and for you both to avoid a very expensive litigation or arbitration. So at this stage, consider whether negotiations should be commenced. Now, negotiations might, the timing of this might very much, will very much rather depend upon the circumstances of the claim. And it's important that before negotiations are commenced, those involved or those that will be involved in those negotiations fully understand the matters that are in dispute and have been able to fully assess the issues that are in dispute. Just bear that in mind when thinking about exactly when negotiations should happen. As to where they should happen, at the moment, the negotiations might have to take place on a virtual basis, obviously, but face-to-face meetings are always best, if possible. So consider whether a neutral location is needed, or whether it would be best to meet at the project location, or the location that is most convenient to both parties. Obviously, if it is most convenient to both parties, then that will help ensure that any message of good faith is preserved. And what you don't want to be doing at this stage is undermining the good faith nature of any settlement negotiations. So who should then be involved? Again, this is one to consider whether it should be management only, or whether it should be management with legal, or management with the technical team, or management, legal and technical. Of course, if negotiations to settle are to take place, then it's very important that those involved not only fully understand the issues, but that they have, or at least one of them has authority to settle the matter. Consider whether or not the negotiations should take place on a without prejudice basis or an open basis. Do you want the other side to be able to refer later to what you may or may not have said during these discussions? Likewise, do you want to be able to refer to what they may or may not have said during these discussions in a subsequent litigation or arbitration? In our experience, it's always best for negotiations at this stage possibly to take place, at least initially, on a without prejudice basis. Finally, consider whether there is a clear strategy and whether you know what the parameters are for negotiating settlement. The last thing you want to do is to go into a negotiation not actually knowing where you might be willing to end up, because in that way you might end up in a situation which you later think, well, I'm not altogether happy with that situation. So just be very clear, what is your strategy? Now, any settlement negotiation, if it does lead to settlement, will then need to have documents recording that settlement. It's likely that a settlement agreement will be required. You may also need to consider whether an amendment to the contract is needed. You should consider in this regard, with regards to any terms of settlement, whether those terms need to remain confidential. If there's a payment that needs to be made, then you need to consider what the timing of that payment should be and what will happen if the payment is not made. Will the whole settlement agreement fall over? Or will you then just seek to enforce the terms of the settlement agreement and seek to recover that payment. Likewise, if you're the party paying, then you need to consider what would best suit you in those circumstances. Finally, consider enforcement of the settlement terms and factor that into your drafting. Because at the end of the day, you want to ensure that whatever you agree is binding on both parties and, if necessary, can be enforced if the terms that have been agreed are not adhered to. So I now want to just move on to some budgeting and timetabling issues. Now, let's assume that you've gone through the settlement process, that you've tried to negotiate matters with your counterparty, and that you've not been successful. In those circumstances, you might now be heading towards the courts for litigation, or alternatively to arbitration if you have an arbitration clause in your contract. Time is, of course, money, and disputes can be costly in a number of ways. They can be costly in relation to the management time that is taken up, the legal costs, obviously, the costs of experts that may be involved. There may be a cost to the business in not having the cash flow that it might have expected. And in any event, disputes are always an unwelcome distraction from day-to-day business. So it's important, therefore, that the expectations are at the right level. Unexpected costs are, of course, never welcome, and it's therefore important to manage the expectations from the earliest possible stage regarding both time and money. If court or arbitration proceedings are being contemplated, then a cost estimate should be prepared before proceedings are commenced. It will likely be based on a number of assumptions, but hopefully there will be clarity with regards to the anticipated scope, and consideration can then be given as to the proportionality of the sums in dispute against the costs that may be involved if the matter is litigated or arbitrated. Now, of course, the estimate will be subject to various caveats. As I say, it will be based on assumptions such as the number of witnesses, the number of experts, and if arbitration, the number of arbitrators involved, and generally the length of the process, the nature and number of hearings, and whether or not there is or is not a counterclaim. But all of this needs to be considered before you commence litigation and arbitration, or before you basically dismiss a potential settlement that might avoid avoid litigation or arbitration. Also, with regards to the commencement of proceedings, consider at this stage whether you want to actively commence proceedings or whether you want to wait for the other side to initiate proceedings. Consider whether there's something that needs to be stopped, whether there is a need for an application for injunction. Consider whether there are timing issues that need to be looked at. For example, if there's a limitation period, then there may be the need for a protective writ or a standstill agreement, which is certainly something available under English law. Also think about, well, if you are going to end up in a litigation or arbitration, and if you are going to need experts, then think about who you might want to appoint in that regard, so that you can secure those experts or potential experts at this early stage and not be beaten to the post, as it were, by the counterparty who might then secure them before you do. The same is true in relation to potential arbitrators in an arbitration. Now, in respect of timescale, when proceedings are commenced, the court or tribunal will want to fix a timetable that the parties should follow. And it's important that the team managing the dispute involves the key stakeholders from the business when agreeing that timetable, so as to ensure that all circumstances are taken into account, including the availability of documents, experts, and witnesses. The timetable must be achievable, and the expectations of those in the business must be appropriately aligned to it. So we recommend that a timetable for the business is also created at this stage, so that any key stages that are dependent on the business are identified early. Now, I'd like to pass back to Sarah, and Sarah will speak to you about document management and the dangers of document production.
Thank you, Rob. Yeah, I think a recurring theme during our talk today has been about documents that you need to be looking for, documents that you shouldn't be creating if a dispute arises, or documents that you need to be thoughtful about creating once a dispute or an issue has arisen. We will often see document management systems that are, I think, difficult to get into, where it's hard for a client to actually identify where the right documents sit, and then other circumstances where this has been very well organized. And so it can be very helpful to think about how documents are going to be organized and sit on your document management system. That's always very helpful once an issue arises. With regards to managing documents once a contentious situation arises, you'll want to think about whether it's necessary to have software to assist with management of that. And I would say, unless you have a very, very small number of documents, software can be of huge assistance and is likely to reduce the amount of time that's required to look at those documents and to, I think, take a record of what they mean and to sort them appropriately. And so we will often, we frequently use software to assist with that process. Examples of that are ones such as CMS Evidence. To give you an idea, that's really a platform where it's possible to review documents. So you can have many, many thousands or millions of emails, and you can sort them in particular ways and keyword search. And then we also have things like Brainspace, where it's much more interesting because it applies artificial intelligence or uses artificial intelligence to look for trends or certain things in a pool of documents. And so that has also been insightful at the early stages of a dispute. So I think the main thing to be thinking about is, if you're looking at this at the beginning of a project, it can be extremely helpful to actually put in place a management system and a protocol so that documents are stored in a particular way. And once you get to the stage where you need to be harvesting documents and providing them to your external lawyers, you will be wanting to think seriously about how to do that in a very controlled manner so that you're being efficient about it and not spending excessive amounts in fees. So we always find it to be more efficient to use these sorts of tools. It's really all I've got to say on document management. So I think I'm going to now be handing over to Rob, who's going to be speaking to you about ADR options. And the first of those is mediation.
Thank you, Sarah. So just to recap, before we get into mediation, when it comes to avoiding disputes, you just need to make sure you've identified the issues, got your team organized, then identified what if possible, and then prepare to avoid the dispute arising. Sarah, hopefully that's better. So litigation may be an option, but we're not going to consider that today. It will be very much dependent upon where you're located. Sarah will speak to you about arbitration. But with regards to mediation, well, mediation, as I say, is a form of alternative dispute resolution. It is a without prejudice process. It is a process that involves a neutral third party who will facilitate a structured negotiation between the two parties, or there may be more than two parties involved. And the process will rely very much on the cooperation of the parties to the potential dispute or to the litigation or arbitration, if that has already been commenced. Now, the mediator is there to assist the parties in trying to achieve a settlement. He or she is not an advisor, and they should not offer advice. He or she is not a judge or arbitrator and should therefore not make a decision on any issue. Mediation, as we've heard, may be a contractual requirement, but more often than not, it happens on an ad hoc basis, and it's proposed usually on a without prejudice basis by one party or the other in an attempt to settle. And as I've already mentioned, that could happen after commencement of litigation or arbitration, or indeed before the commencement of those processes. In any event, mediation requires parties to cooperate in scheduling the mediation and in jointly appointing the mediator. It's not a formal process, it's not constrained by any particular framework or rules of procedure, and it can take place in whatever way the parties and the mediator decide. Now, before the mediation takes place, those involved must sign a mediation agreement, and in that agreement they will confirm that what will be discussed during the mediation will be non-binding and confidential unless that is otherwise agreed. Likewise, any documents prepared for the purposes of mediation will also remain confidential and will not be capable of being relied upon later in any proceedings that may follow. The parties themselves will attend the mediation. They are in fact the key players, not the lawyers, but the actual members of each organization that is in dispute. Lawyers will usually accompany them, but in any event, where a company or other corporate entity is involved, the person who attends on its behalf must be authorized to reach a binding settlement during the mediation. That is one of the main requirements of mediation. Any settlement reached will usually be reflected in a written settlement agreement, and that agreement will be drafted and signed during the mediation, and that agreement will then be legally binding. But it may be stated in that agreement that the terms agreed nonetheless will remain confidential and cannot be shared with anyone else unless that is consented to by both parties. Settlement outcomes are not limited to monetary solutions, and this means that the wider commercial relationship, if any, between the parties can also be factored into the terms that are agreed. As I've mentioned, all discussions during a mediation are confidential and without prejudice to any rights which the parties would have in relation to legal proceedings. So if the mediation fails and the parties move to litigation or arbitration, it is important that these rights have not been prejudiced, and they will not have been prejudiced, providing that the parties have continued to operate on that without prejudice basis. And the only change would happen if the parties actually agreed to a settlement, and the terms of the settlement agreement were then stated to be open and not confidential and not without prejudice. Sorry, just to be clear, the settlement agreement would by its nature have to not be without prejudice in order for it then to be enforceable. Now, I'm conscious of time, so I'm not going to move into the detail of the process involved in mediation. Instead, I'm going to hand back the stage to Sarah, who will speak to you about arbitration.
Thank you, Rob. I will do this quickly because I'm conscious of time, and I'm just going to leave my camera off because we seem to be having some feed issues. I think the one thing you just want to think about, and I'm thinking here particularly about if you are at the point where you're choosing what is to go into your arbitration agreement, you will want to think about some of the things that are listed on this slide, because my experience is that often these sorts of things are not really thought about, and then you get to a dispute and realize actually you have a seat in a jurisdiction which is particularly undesirable, or the parties have agreed to a sole arbitrator for all arbitrations, and actually on the advice of your external lawyers you might decide that it's much better to have 3 arbitrators and you don't have that choice anymore. And also one of the points on here is ad hoc or institutional. Institutional arbitrations will cost money in the sense that there is a fee to be paid to the institution, but there are great benefits to be had in having someone oversee the initial stages of the arbitration in particular and being able to push the parties to actually take the steps that are required. And so that's something to think about. Some institutions will charge you an amount that is essentially an hourly rate, and that rate will be capped. Others will charge you based upon a percentage of the claim. Some people can end up finding that to be a very surprising and dissatisfying situation to be in. For example, you might have a very significant claim where actually the issues in dispute are reasonably straightforward in that it might be an issue of contract interpretation, and you don't really want to be paying an institution by reference to the sum in dispute. And so you will want to think about that at the time of the arbitration agreement being agreed. And there are numerous other things to be thinking about. And I think that the best advice is really to make sure that you run that by your internal lawyers. And if you don't have in-house counsel, it is always good to have that run by external lawyers. And it wouldn't be a costly exercise to do so. But all of these are things to think about, how the dispute is actually going to proceed if it becomes a dispute. And at this stage, all of these things will come into sharp focus. And so it can be very important to work them out in the first instance so you don't face issues. But obviously, once a dispute arises, the first place you should be turning to in your contract, if you're seeking to understand what's required of you in relation to arbitration, is the arbitration agreement itself. Right, okay, well, thank you very much for listening to Rob and myself. And now I think, actually, Rashid, are we going to be doing questions at the very end or now for the two of us?
Yeah, well, I think it's probably advisable to do it at the end, simply because we have a presentation which deals about the same issues along the same lines, but under Kazakh legislation, the Kazakh practice, etc., from Yernur Toizhanov. So I suggest we listen to Yernur first and then have consolidated kind of approach to questions and comments, etc. And I would urge people to send questions or comments, etc., via questions and answers function, which is in the upper end at the top of their screens. So, and then I will probably have to read these questions out, and then obviously, I guess everyone will want to contribute answering these questions. So I suggest questions answered at the end, and now we have Yernur Toizhanov, who is a legal manager at KPMG in Kazakhstan and Central Asia. Yernur is based in Atyrau, mainly works on Western Kazakhstan sort of projects and matters, etc. Sometimes he's involved in a number of other kind of client files all across Kazakhstan and outside of Kazakhstan as well. So, Yernur, over to you.
Yeah, Rashid, thank you for the introduction. Okay, so dear ladies and gentlemen, I'm very pleased to present on the topic of management of disputes and disputes avoidance in Kazakhstan. As Rashid has already mentioned, I will mainly focus on the general approach of management of disputes and some specifics from perspective of Kazakhstan legal framework. So, why is better to avoid disputes? So it provides us for an option to avoid substantial costs of dispute resolution, avoid erosion of trust in business relationship with the other party, and it also provides an option to avoid a negative reputational impact. What are the main causes of contractual conflicts? Basically, these are the unexpected changes in scope of work, escalation of price due to inflation, currency fluctuation, which arises quite often here in Kazakhstan, suspension of work supply. This also has been a problem due to quarantine measures imposed by the government. Difference in quantity and quality of goods and works, force majeure. Actual work site differs from that specified in the contract. This might be also an issue. Unclear allocation of risk, which between responsible parties and persons involved, and unclear clauses on possession prior to completion or delivery. And the last but not least, lack of clarity in specifications and drawings. These causes might apply to various types of contracts, such as construction or delivery of goods. It doesn't matter. So, what preventive measures can be taken to basically some disputes may be prevented at the stage of negotiations and contract formation. A potential dispute can arise at the start of the contractual relationship or any time during its term. It may also occur when one of the parties recognizes that it has issues that bother it, but which are not significant enough at the time to cause that party to raise them officially with the other party. Also, potential dispute may occur where one of the parties has more power of negotiation and more leverage. So preventive measures provide us to avoid misunderstandings, unrealistic expectations. It is also better to ensure that contract contains precise provisions on the quality, payment mechanisms, deadlines, and terms and risk allocation. The contract should also contain procedures for pre-trial settlement of disputes and terms and conditions which enable early dispute recognition. So what are the warning signs of a potential dispute, of an upcoming dispute? These are, during the project, many questions arise during the performance of contract. Important issues are resolved during the performance of contract. Initial terms and conditions are constantly being amended or changed during the project. And communications between the client and the contractor lack clarity and timelines. So these are the warning signs of an upcoming conflict and dispute. So when risks are not clearly assigned, conflicts often occur. When conflict is poorly managed, it might become a claim. When claim remains unresolved, it might turn into a dispute. So it is better to do your homework and be prepared before making any actions. So the first step is to identify applicable law. What is an applicable law? It affects the interpretation of the contractual clauses. Do you need to engage lawyers from other jurisdictions? Then identify forum where the dispute will be resolved. Do you need to engage lawyers from other jurisdictions? Will you be able to enforce court decision or arbitration award in this forum? Grounds for the claim. Is there a violation of the right? Identify the right and the violation. Evidence. What evidence do you have? Are documents completed and ready to be presented to the court or arbitration? Do you have contact with people who were engaged in the conflict and during whole life cycle of the contract? Develop a strategy and choose tactics. Should you initiate court proceedings? Are there any potential counterclaims from the other party? Is it going to court? Is going to court worth it overall? It is better to compare costs and potential results. How strong is your position? Do you have good evidence? For instance, in construction, client in most of cases has access to the site and documents, and the contractor may have a limited access or no access at all. Is it better to act aggressively or should we slow down? And you should also keep in mind the statute of limitations. So negotiation is available where the parties are both interested in smooth and quick problem solving and maintaining good business relations. They are ready to make mutual concessions. Negotiation may be used before the dispute has arisen. Pre-trial dispute settlement shall be used when the dispute has already arisen. Pre-trial dispute settlement may be required for a certain category of cases before going to court under Kazakh laws. So Pre-trial procedure may be also required under the contractual provisions as well as the mandatory provision. Although the parties are allowed to settle the dispute through the participatory procedure or mediation without involvement of litigation or arbitration, initiation of these procedures within the framework of the litigation is preferable, since in such case, the agreement on dispute settlement will be approved by the court and may be then submitted for execution faster if one of the parties violates such agreement. Pre-trial dispute settlement. At this stage, it is very important to make sure that the letter of complaint is considered as a pre-trial claim by both parties. The complaining party is recommended to identify the violation made by the other party, set a time limit for its elimination, and the consequences of failure to eliminate the violation in time. The other party responses to the complaint or might just ignore it. It is important first to keep in mind that the statute of limitation, make sure the letters are sent in the order prescribed by the contract. Otherwise, failure to comply with such procedure may the court may consider later on as a failure to try to dispute settlement before applying to court. And the last one is all communication must be recorded and monitored very carefully due to the fact that documents, letters, responses, and even waybills will be used in court in case of litigation. At this stage, the dispute may be resolved when the violating party basically agrees with the other party and is willing to maintain good business relations. This method may also be useful to encourage the violating party to fix the issue and execute its obligations as soon as possible. Participatory procedure. So the parties shall have the right to file a petition for the settlement of the dispute in the manner of participatory procedure before the court leaves the courtroom to make a decision. The participatory procedure is carried out with the participation of a judge through negotiations between the parties to resolve the dispute with the assistance of lawyers of both parties. And so a judge never participates in such procedures. The parties negotiate to resolve the dispute with the assistance of lawyers of both parties. And the result is basically a participatory dispute settlement agreement. Mediation. Mediation in Kazakhstan. Basically, the parties have the right prior to the removal of the court to make a decision in the courts of the first appeal or cassation level to file a petition for the settlement of the dispute by way of mediation with the assistance of a judge or a mediator. The judge who conducts the mediation appoints the day of the mediation and notifies the parties of the time and place of the mediation. In such case, mediation is carried out by a judge in accordance with the procedure set by the law on mediation. At the request of the parties, the court has the right to postpone the mediation procedure and summon other persons for mediation if their participation will contribute to the settlement of the dispute. If the parties have not reached an agreement on the settlement of the dispute by way of mediation with the assistance of a judge, the materials related to the case are transferred for consideration to another judge for litigation process to begin. With the consent, however, with the consent of the other parties, the case may be considered by the same judge who actually conducted the mediation. In such cases, it might also save some time for the litigation process. The judge itself has already reviewed the evidence and positions of each party. Upon receipt of a petition for the settlement of a dispute by way of mediation, in a case pending before a court or first or appellate instance, the court shall have the right to suspend proceedings for a period not exceeding 10 working days. Upon receipt of a request for the settlement of a dispute by way of mediation with the assistance of a mediator, in a case pending before a court of first or appeal instance, and presenting an agreement concluded by the parties with the mediator, the court is obliged to suspend the proceedings for a period not exceeding 1 month. The petition of the parties for the settlement of a dispute by way of mediation may be filed in the Court of Cassation if this does not require additional procedural actions and suspension of the consideration of the case. Simultaneously with the petition in Court of Cassation, the parties must submit an agreement on the settlement of the dispute by way of mediation. The protocol of mediation itself is not kept in court. If an agreement on the settlement of a dispute by way of mediation is concluded at the stage of execution of a judicial act, it shall be submitted for approval to the court of first instance at the place of execution of the judicial act, or to the court that issued the specified judicial act. Well, yeah, thank you very much for your attention, and I would be pleased to answer any questions.
Right, Yernur, thank you very much. I think I will ask probably Rob and Sarah to come back to the audience and have video, hopefully. Sarah, can you join us as well now? Sarah? Yeah, okay. Well, let's start with questions. I don't think we have anyone from the audience yet. So as a moderator, I'll probably, usually, you know, as a moderator, you don't usually have a kind of opportunity to ask your own question because there are lots of questions from the audience. Today is an exception, so I would like to enjoy my right to answer and grill you if you don't mind. So Rob, Sarah, and maybe Yernur as well, you all were referring to negotiations, talk to the other side, try to avoid the dispute, don't litigate until it's very sort of, you know, there is no choice. But my experience, I'm sure experience you have and people in the audience, when you have a dispute, it probably is a stage when people don't talk to each other. They yell at each other and they probably send very kind of threatening letters and trying to sort of somehow use different means and forces and whatever just to make sure that they win and they sort of, you know, look good in their own organizations, because obviously no one would probably want to say that, well, we failed, that's why we have a dispute, so we have to pay, and you know, the other side is right or partly right or whatever. So I don't think this is realistic, and maybe it's realistic somewhere else, but in Kazakhstan, from what I see, it's very, very difficult to get people together and start them talking. And probably by talking, they will resolve most of the issues. But I think the problem is how to make sure that they talk to each other and how to help them to negotiate. So that's my question. Do you have any practical tips, what to do, how to use this?
Shall I jump in, Rob, and then you can
Yeah, go for it.
I think what I would say to that, I mean, I absolutely understand that, Rashid. It's a really good question, because one of the things that I see is a different approach from different parties, often based upon their cultural background. And so I have some clients who are extremely, extremely resistant to ever bringing formal dispute resolution proceedings, and often it is very typical of the background that they have. And then you will have other cultures where they are very quick to go off to arbitration, and there's absolutely nothing wrong with that, and to seek to fight their position. I think that what I do see, which seems to be bringing people to a middle ground, is if you have had experience of a very big dispute, and the cost and the time that it takes, and it takes people who would otherwise be on a project away from their day-to-day work, that they will see the benefits of seeking to resolve things early. And so I think it can be reminding people that it can be a very arduous process, and that they may end up with a far better result if they engage early on. I think that's probably what I would be saying in response.
Yeah, if I could just pick up on that. I mean, Rashid, you're right. I mean, when you actually end up with a dispute, capital D, then quite often the relationship is broken down to such an extent that it's very difficult to bring the parties together. I suppose what we're saying here is that when you're working on a contract or dealing with a project, or where an incident arises, anyway, where there's a contentious situation that the business recognizes, then if it can act sooner than it might have previously acted, and it can identify that contentious situation and evaluate the risk relating to that contentious situation, then it can perhaps manage the issues arising in such a way that a dispute with a capital D, as it were, a litigation or arbitration, never actually comes about. And the reason why anyone should try and do that, I mean, Sarah's touched on the cultural issues which make it more difficult in some areas than others for this to happen. But the reasons obviously are, as we've discussed, the massive impact that it has on the business of the company. Now, no business on this earth is really in the business of litigating, with the exception of a few, such as a litigation funding organization or an insurance company, which accepts litigation as a major part of its business, and is willing to fight claims as part of its business in ensuring risk. But most companies are in the business of actually doing something other than litigating. Of course, the other exception are lawyers, such as Sarah and I, who are in the business of dealing with disputes. But even the two of us, recognize that most businesses don't want to be litigating, don't want to be arbitrating. They want to be getting on and making money. They want to be doing something positive with their business and with their time. And it is for that very reason, irrespective of culture, that parties, they may be reluctant to do, to perhaps look at trying to avoid the issues by negotiating, because they may feel compromise is not the right thing. And for individuals within a business, that may well be the case. They may say, well, this is my project. I don't want to be seen to have failed. I'm going to fight this all the way. But for the business as a whole, is that really the right thing to do? So all I would say is, the business and the lawyers, the main thing is for the two parts of the business, those actually on the operational side and those on the legal side, if that relationship is strong and close, and if when issues arise, those issues are shared so that the risk can be evaluated, then the business as a whole can then decide whether or not the right thing to do is to do nothing and wait for a claim to come through the door by way of a writ or by way of an arbitration, or alternative, they can think, well, rather than wait or rather than pursue a claim in that way, we will actually try and resolve these issues and try and avoid the cost and time that will otherwise be incurred. So it's all down to communication. As Sarah said, communication is key. It's very important that people speak to one another, communicate, assess the risks, and then act in the best interests of the business.
Thank you, Rob. Thank you. Yernur, would you like to add anything, or what's your experience?
Well, I totally agree with the position of Rob. Well, probably, yeah.
Another thing which came to my head, and I think it was mentioned earlier on, that sometimes the organizations and dispute is handled somewhere at the bottom or maybe middle of the organization. And my personal experience, the sooner that managers, top managers and shareholders know about this, know that there is a problem with a contract or particular JV issue or whatever, it's probably better. I guess don't shoot the messenger, and probably everyone is very scared to talk to the big bosses that actually there is a problem. But I think that's without kind of this message being delivered, I think the conflict, the dispute itself will not go away, and probably it will become even worse, rather than, if the big bosses somehow intervene and talk to the other side, sort of top managers, etc., and shareholders, who were probably initially dealing with kind of getting the deal together, getting this joint venture, or getting this commercial contract, etc., etc. So I would probably add this to kind of, you know, decision-making process. Just try to talk to the bosses, try to get involved top management and shareholders at the right time, but the sooner the better, probably. If you don't mind, we are a bit short of time, but we do have a question from the audience. So it's Dina Daumova, and her question, I wonder whether this is for all of you, but let's see. Is there any time limit for application to the mediator after court decision came into force and not enforced yet? So I think, in other words, whether there is still possibility for mediating if the court decision came into force but not even enforced yet. So please.
I think what we see most often for mediation is that that it can take, I mean, it can take place at any time, but what is critical really is that it takes place before a decision is made, either by a tribunal in arbitration or by a court. And the reason I would say that is, once the decision has come out, the party that will be, in my view, if they were to be proposing mediation, it would be the party that has lost. And the other side would likely be saying, well, why would we be mediating at this point? So I think that that's the challenge that you would face. And often we refer to it as being a settlement agreed on the doors of the court, but we'll frequently see, before a hearing actually commences, the parties actually settling, because they know that once you get into court, sometimes there is no turning back. Having said that, I have also had matters where they are mid-hearing, and people will take a view, actually, maybe this isn't going so well for us, and they will seek to resolve it with the other side, and an agreement can be reached. But I think you really want to be focusing on doing that before you actually have a decision.
Right. I agree okay. With that entirely. I'd just add, I agree with that entirely. All I'd say, though, is that where you basically have a court process where there are a number of lines of appeal, then you might end up with a decision from the court of first instance, and then there might be an appeal pending. And at that stage, the parties might then, I suppose, in theory, they could potentially come together with a mediator to seek to mediate their position on the basis that there was still a risk that the higher court might overturn the decision of the lower court. I've not seen it happen. As Sarah says, you would normally look to mediate before you actually had a final decision from a court, even if that was the court of first instance, and even if there was an appeal process further up the line. But no, there isn't a time limit to mediation. It's just that you may find that the party's not interested in mediating if one has already got a decision of the court.
Yeah.
Thank you.
And I would also add, from Kazakhstan law perspective, there's no time limit, but in most cases, if the first instance has already issued a decision, the other party in favor of which this decision was made would not be keen to enter into mediation unless the party would file an appeal claim. And if the position in the Court of Appeal would be quite strong from the other party, it might also consider to enter into mediation process, and it's absolutely possible under Kazakhstan legislation. So basically, answering the question, there's no time limit, and even if the court has already issued the decision.
Thank you. Well, I guess that's probably the end of our today's discussion, unless we have any other questions. Oh no, okay, Dina says thank you very much. Yes, and one of the participants just sent me a private message saying that from now on, probably they will try to have more friendly relationships and negotiations rather than getting into dispute and somehow trying to resolve it earlier on, rather than having very expensive lawyers at both sides, etc. So I think with this kind of a comment, I think we probably need to finish now, but I do hope this event, which became kind of annual, will continue next year, or maybe next half a year. We'll do it again, but try to have a different angle to solving disputes, resolving disputes, avoiding disputes in Kazakhstan and elsewhere. Thank you very much, everyone, and thank you, our speakers. Thank you.
Well, thank you, Rashid,
Thank
and thank you, KPMG, for hosting.
Yes, thank you very much. Thank you to
Thanks, everyone.
Stay
Take
safe.
care.
Yeah.
Cheers.
Thank you. Bye-bye.
Bye. Stay safe.
Bye-bye.
Bye.